We're here to discuss and celebrate a book that came out, Public Purpose in International Law. And this comes from Cambridge Press. The subtitle is Rethinking Regulatory Sovereignty in the Global Era. We have with us the two authors of that book, which means we have to now be polite. No. Our two authors are with us, Pedro Martinez-Fraga and C. Ryan Reitz. Both of them are with the law firm Bryan Cave, its office in Miami, and both work in international arbitration. Ryan attended Harvard Law School, and then Harvard University and Harvard College, and then Boston for law school. And Pedro attended undergraduate at a school I have great admiration for. We've talked about this in the past, St. John's. It's a school where you focus on the great books and focus on the dialogue that's embedded in all our history. So it's a great concept. It's very challenging. Graduates tend to be very unusual. And then he attended.
Thanks, David.
I would have loved to have gone. And then attended Columbia Law School. Let me just say one thing in the beginning. I have 2 pages in the front of this book. It was my pleasure to be asked to write the introduction, and it's some of that will come out, or a forward to the book. And it's I think, a stunning book. One would have thought an academic would have done this book. And it took 2 practitioners with academic tendencies to do this book. And so it's really an impressive feat. The way I like to think about it is, you've been arguing before judges, before arbitrators. Everything is in English. And part of the problem is everything is in English in a subtle way. So coming here as dean, to be dean from the United States, I've thought at times it would have been better if it had been in a different language, because then I at least would have known what they really mean when they say certain words. A different way to think about it is, if you have arbitrators from different perspectives, they actually cannot talk to each other. It's very difficult. This is a Mac operating system. I'm a PC operating system, and he's a Linux operating system. And we think we're all typing into an English keyboard, but actually a lot of miscommunication is happening as you go along. The fact that you have an applicable law helps, because at least the 3 of us try to think about the same applicable law and do things. The problem is the applicable law has phrases that whose content are really not known. And you start to use them with each other, and you actually can be talking past each other without realizing it. And that's the deeper level, to me, of this book, to realize that public purpose is a very elusive phrase. That's my quick take on what's happening. We're going to have a conversation, so let me start with Ryan. What would have led you to think about doing this book?
Well, in terms of thinking about public purpose and its leading to thought about it, what it means, and then the desire to do a book on it, we in our practice we encounter public purpose in 2 main areas. Both in connection with expropriation. Having read a bit or 2, all of you, I think, are familiar with the idea that most BITs provide, and customary international law provides, that property can't be expropriated unless it's for a public purpose and meets certain other criteria, including compensation and other things. And we looked at that language and said, what does that mean? Does that have any effective meaning? Meaning, doesn't matter whether property is expropriated for a public purpose or not, because after all, there's the compensation phrase at the end of it. We also see public purpose in the context of indirect expropriation, where you have a question about whether a regulation is sufficient to constitute an expropriation. And you have the Methanex formulation, which says that provided that certain criteria are met, including public purpose, that a regulatory taking may not be an expropriation. And so we saw this context in our practice, this concept in our practice, and it raises several questions. Its effectiveness, whether it matters in the context of the standard expropriation context, and what are the consequences if something is not done for a public purpose in those two contexts. And in looking at the problem or the issues, we saw that traditionally and historically public purpose is a very, very broad concept. It really means whatever's done in the name of the state, or at least for the good of the state. And that doesn't seem to necessarily be what's intended when we talk about that anymore. But that's the statement that we've seen in the literature. We also saw that there's no rigorous definition of public purpose anywhere. And so we started to look at the concept from a variety of different perspectives. What do we see not only in investment law, in BITs and other instruments that are relevant, but in other fields of law, including human rights law, including writings on permanent sovereignty over natural resources, and some other things that I think Pedro will talk about. And we ended up looking at the doctrine from three perspectives: the historical, what is it and how did it develop; the descriptive, what does it appear to be today; and finally a prescriptive context where we are trying to make some suggestions about what we think can be done with the doctrine and make it more useful. And having thought about it, it seemed to be a waste not to try to put it down on paper.
Can I just ask, so the book opens with a discussion of Athens and a discussion of the Greeks. Did that originate with you?
Well, that actually originated with Pedro.
So I say that as a joke because that it would be St. John's that would have trained you to have that background. Maybe I'm wrong.
No, you're right. Actually, it was both necessity and St. John's. But the real issue became, where do we first find the concept of public purpose applied to the concept of property, or the taking of property, the transformation of property and ownership. And when we started looking for it, we ended up looking at Thucydides and Homer. And there we found that the word for slave, which first appears in Homer as the word demos, and then later appears in classical Attic Greek, the Greek of Aristotle, Plato, the great playwrights, Euclid, it appears as andropadon, but both have a common denominator. They fundamentally mean, not too loosely translated, chattel with feet. And we learn that the Greeks, the Greek polis, the different Greek city-states, had a rule of law that fundamentally said that a foreigner could be treated as precisely chattel with feet once that foreigner crosses into the territorial domain of the city-state. And that was the first taking. And these takings were justified, slavery in effect was justified in Attic Greek, fundamentally by a concept that is very, very close to what we identify in the book as the legacy public purpose doctrine, i.e. the public purpose doctrine that we find in most BITs, in most multilateral investment treaties, and in most arbitral awards. Namely, that the king or commonwealth can take anything so long as it's for a public purpose and is done so, quote, fairly, within the rules of the polis. That is remarkably close. So the question became, is there an exception to this rule in classical Greece? And we found an exception that is almost divine in nature. And there the word that became critical is the word for treaty, which is spondon. Ex spondon outside the treaty, en spondon within the treaty or signatory. But we also found that that word was connected to another concept called libations not meant to be had. In other words, the wine that you don't consume yourself, but rather you offer to the gods, which is what was done at the end of every treaty. So the single exception to a public purpose taking in antiquity is A, a treaty, and B, something that is quasi-divine in nature, which is the sealing and respect for a treaty in the typical Orthodox Greek celebration of having accomplished something between two or more city-states. So that it's a very serious exception that provides a foreigner with non-foreigner status. And that's how the Greek came into this.
So you know there's other articles on laws of war, and the Greeks have no laws of war unless it deals with religion, the ancient Greeks. And there are many, and it turns about how you will lose following because of that. Can I just ask, introduce, we have a commentator with us, Wise Reflections, Dr. Federico Ortino of King's College, and he's going to join in here as we go along.
Yes.
But maybe this would be a good moment to start, and I just would say I'm going to welcome questions at any time, too. But Federico.
Well, first of all, I have to commend the authors, and in fact, any author in that sense, who embark in such a project and with such successful results. Despite what people say, writing a book is absolutely not such an easy task. Now, when it comes to the subject matter, maybe it's one of the fascinating aspects of this area. And although the book is actually broader than that, but let's focus on investment law given the context. One of the fascinating aspects of international investment law is exactly the multitude of values that are expressed and present in a very basic document as a BIT. And these values tend to be, at least today, I think they are mostly, uncontroversially positive values. And so, public purpose is certainly one, public good, development, prosperity, property protection, encouraging investment, flow of investment, but even going to fairness, non-discrimination, equity, reasonableness, due process, and why not? Protection of public health, environment, sustainable development, human rights. And they're all there as values. Now, the trick is, and in fact, maybe the beauty of this, is that all these values have to be defined and somehow have to work together. And I think this is sort of, to my view, one of the sort of contribution that this book provides is exactly in showing the difficulty in defining these uncontroversial values that often are transformed into legal provision. This is a sort of a narrow area this is what we do today as lawyers, but these are basically values and how we define them and how we relate them in some workable way. And this is sort of the big task in front of us, and that's what I like a lot about this area of the law. Now, to be more specific, the book tackles sort of the starting point is an examination of NAFTA, and I guess the ultimate conclusion of their analysis is a rather pessimistic one, in the sense that whether the treaty content and structure, as well as the way that the public policy doctrine has been interpreted and applied by tribunals subsequently, has not really led to certainly clarity of how you define a concept such as public policy, public purpose, and And even aside from the lack of clarity, it seems to be that there is a prevalent approach that rests on a definition of public purpose that favors this subjective exercise of sovereignty by the host state, which is, in a way, unrestrained and uncontrolled. I mean, and there are, in this examination is, and I, to some extent, I agree. I certainly agree that even only focusing on the expropriation provision in NAFTA, you are left with the impression that you don't really know, particularly what an indirect expropriation is. You contrast this sort of focus on effects on the investment, which is exemplified in the metal clad decision as examined in the book. And on the other hand, you have the sort of the police powers approach, which is basically only seems to rely on an unlimited discretion on the host state to regulate, as in Methanex. And there is something in between, but in fact it's very undeveloped or underdeveloped. Even the recent statements in cases such as Kentura, maybe they are hinting to some better, more clear future, but there isn't really much in there. Maybe just before concluding, I don't want to take too much time and open it up. I want to highlight two aspects just by looking at this preliminary conclusion. The first one is the book clearly highlights the usefulness of a comparative analysis. Comparative in the sense of looking at other areas of international law in order to understand better the area that you are focusing on. And so clearly here the focus on international trade law particularly, but other areas as well. But I think more importantly, the book highlights the pitfalls and the risks in a too easy comparison and transposition of principles and doctrines that have developed in a different area, in a different context. And so that I think is an important message, particularly if you think of the current discussion that sort of have animated the last few months in not having to do with the substantive aspect of investment law, but the dispute settlement one, and the idea of importing the appellate body mechanism from the WTO into the investment context. Now, I'm not arguing that that is per se a wrong approach, but there are advantages and disadvantages in looking at the appellate body as an institute, as an institution, and bring it into the investment area. Transposition have to be carried out with very much care and caution. The second and last point is perhaps one which is actually crucial, and maybe I would want to come back to it. I mean, the book, looking at, in its conclusion about the NAFTA text being too lenient vis-a-vis host states, and then the conclusion then NAFTA jurisprudence with regard to expropriation has also been too lenient, or hasn't developed a proper doctrine of the public purpose. I think there's a question there behind these two conclusions, and is who is supposed to decide? Not much the definition, but mostly the interaction between all these different values that are captured and that are relevant in our context. And perhaps that question sort of remains for me an open question. I think historically, and maybe this explains the findings of the book, that today the pendulum still swings in favor of the host state is because traditionally they are the masters of international law, and they decide the interrelationship and links between all the different concepts. And maybe I launched there sort of this the book, I don't think it even mentions it, but I think the book is a demand and a request and a hopeful for a sort of constitutionalization of international law. Maybe I'm going beyond, I'm an academic hat, but there is inherently in what the authors are doing, there's a demand that the determination of the interrelationship among all these different values should not be left to the individual states. And in the sense, this sort of seems to me to requesting some sort of higher setting of the values that are relevant in international law, and in particular in the context of regulating the global economy. And I stop.
Right, and I think authors get to have a response here. Sure, please, Pedro.
First of all, thank you for both your observations and for taking the time to read the book. I personally feel that it's a great book for medical reasons because the Center for Disease Control tells us that 67% of the global population suffers from sleeping irregularities. And if you read this book, it's all natural, no side effects, and it's a cure. But looking at it with a little bit more seriousness, what the book tries to say is, in response to both professors, is that the paradigm of globalization, economic globalization, has changed and necessarily must change many of the fundamental principles of international law. So that where you have a paradigm where the relationship between and among states is one of interdependence and not one of independence, then issues and concepts such as public purpose need to be transnational, not international. In other words, they have to address issues common to all states and not common to just a few states. And in this sense, I do think that our aspiration was well beyond that of just developing elements for a doctrine, which, by the way, we did not purport to develop. We set out a number of suggestions that Ryan will get into later, but it's a non-exhaustive list of considerations for public purpose. But if, in fact, you have transnational law, and if, in fact, you're now in a paradigm of interdependence and not independence, a public purpose that is defined as all things public, as defined by the state and not susceptible to challenge, leading to all or nothing conclusions, i.e., not acknowledging the proportionality principle of international law, which becomes key in an era of economic globalization, is no longer a workable principle. And fundamentally, that's what we see when we take NAFTA, which works, which is an excellent rubric, and which, by the way, we picked NAFTA because we thought that it would be the most complete and comprehensive petri dish, microcosm of all of international law. In large measure because NAFTA undertook the very bold step in Chapter 1101, subsection 4, to try to describe public purpose. And it does something very similar later on in 1106, subsection 6. Moreover, NAFTA also has its own jurisprudence, so it has its own decisional law, which, again, tries to redeem the promise, the aspiration of defining the elements within the NAFTA rubric. And NAFTA has the added benefit that if you look at NAFTA,
Mr. Rapke again.
Absolutely. If you look at NAFTA, it has 8 sections, 22 chapters, but of those 22 chapters, only one is an investment chapter. The other ones are trade chapter. And it has 7 annexes. Moreover, that one chapter, Chapter 11, as a matter of law within the NAFTA framework is subordinated, if there's ever a conflict, to the international trade sections. So in this sense, it also mirrors what we see in the world of international conventional law, and in some sense, customary international law. So the NAFTA, when we looked at the NAFTA closely, including the different types of public purposes, some more important than others, but a NAFTA that does not identify hierarchy. When we look at the jurisprudence of the NAFTA through the prism of public purpose, we see that public purpose within the rubric of the NAFTA helps define A, the regulatory space of states, B, the relationship between international trade law and international protection, investment protection law. C, plays a pivotal role in the tests generated by the jurisprudence, the effects test, the sole effects test, the effects plus test, and ultimately, even though it arises in TechMed, which is not a NAFTA case per se, but historically, because it is Spain and Mexico in effect, treated together or analyzed within the NAFTA jurisprudence, a proportionality test. In all of these, we see public purpose playing a very important role. And while there's ultimate functionality, the reality is that there is no conceptual uniformity. We see relativism. And this is what is disregarded, this is what is disquieting and disconcerting about the public purpose doctrine, that it is so ubiquitous, and it is so important, yet at the same time, it is not being used as the economic context of the international, public international law that we see now cries and needs for it to be used.
Before I go to Ryan, can I just follow on that with you for a second? When you think of public purpose being elusive in that way, and disquieting was the word you used, is it that someone could crack it and make it more precise? Is it elusive because it needs to be elusive at this point in moving from independence to interdependence?
Absolutely, I think it is elusive because it is in a historical mode of transitioning. So that is part of it being elusive, but I think that it's elusive in a deeper and more meaningful way, which is and which I think affects all of public international law, which is we've been placing a lot of emphasis on process definition and process development rather than in principle development. We have been resting on the old principles without really developing them and trying to develop the methodologies, the tests. And we have to step back and say, these tests, what are they comprised of? Well, they're comprised of elements. What are these elements? These are these principles that date back to the 19th century and before. And that we haven't changed. So I think that once we make this conceptual adjustment, this concept of public purpose and many others will be of more utility to us and better in helping us define all these workings, including the actual sphere, regulatory sphere of states.
So Ryan, I'm trying to get the conversation the two of you were having at some point. No, I want this chapter. You're missing something here. What's your reaction to Federico and to your co-author?
Well, first of all, let me echo Pedro's thanks to both of you for your very kind and thoughtful comments. It's always helpful to hear perspectives, and we had, of course, your input in writing the book, which we also greatly appreciated. But Federico's comment about perhaps we have sort of a constitutionalist call for change here, I interpret it to be a very kind way of asking, a very polite way of asking, is this realistic? After all, host states decide what aspects of their sovereignty they wish to relinquish. They have historically made the rules, and short of having a world legislature, can we do anything constructive here? And we would like to think that the answer is yes, even absent a full, constitutionalist structure, because of the changes that Pedro talked about leading to interdependence. We see, a very interesting thing in recent years, that host and home states are no longer always clearly distinguishable. The capital importing and capital exporting states have sometimes swapped or sometimes mixed their roles, and that states perceive that they have more than one vector of interest in certainly in investment law, but hopefully in international law as well. And so we would like to think that there can be a conversation among the international community ongoing, and the way that customary international law is eventually and slowly made, that will take the concerns with public purpose into account and take the interests of the various stakeholders, players, interest holders into account. And through the evolution of various instruments, treaties, multinational pacts of various types, even arbitral awards, move in a direction that we're advocating. And there's an interesting question about the role of arbitral tribunals. I mean, on the one hand, arbitral tribunals should not be making international legal policy. They're limited to the facts and the arguments before them. They're people chosen from a very select but distinctive group of participants. They're really often deciding these things without the same sort of concern towards future consequences that a common law judge might have. But on the other hand, they've been responsible for developing so much of the law that we look at in this field. So it may be that the world going on in the way that it does will help us move in that direction, although obviously it would be wonderful to have a clearly defined from on high standard that we could look to and say, now I can rest, now I know what public purpose is. But it's a really fascinating question that you raise.
So you don't think you'll be unhappy when there's a standard?
Well, another conversation that has come up from time to time is that uncertainty is good for practicing lawyers. There's always
Are
more
there
work.
questions? Professor Gibson.
Yes, I understand your book came out earlier this year, and now I'm inspired to read it. So thank you very much for the introduction to some of the ideas. When you wrote your book, did you sort of look across the water at the public policy exception to enforcement of arbitral awards? So rather than public purpose as a condition for lawful expropriation, courts are saying we're invoking public policy as a means to refuse to enforce an international commercial arbitral award. And you can see that a number of courts that sort of around the world have looked to each other to try to narrow that definition. So did you take any look at that and draw any parallels or any distinctions between those two, public purpose, public policy, in that other context?
No, we didn't. We were very aware of it, but we couldn't. It was just it would be way. It was just too much. But it's something that we looked at very closely. We did think that public policy, within the context of enforceability of arbitral awards, it's a related second cousin, but a second cousin nonetheless. What we did look at, which I think is it's in that direction, are FIPS, Foreign Investment Protection Statutes. And we looked at 17 of them through different parts of the world. And reaching out to what you're saying and also bringing together what Federico's observations, we find the FIPS to be a very interesting instruments that have been in many ways abandoned. The FIPS, as you know, range, if you look at Vietnam and Egypt, those foreign investment protection statutes are extremely elaborate in providing foreign investment protection or promising foreign investment protection. In fact, they define foreign investment protection as a public purpose above all others. If you look at China's foreign investment protection statute, it offers neither economic incentives nor legal protection. It just fundamentally says something like, this is a welcoming environment and there are many opportunities here. If you look at other foreign investment protection statutes, such as Kuwait, for example, or the Foreign Investment Protection Statute of Laos, for example, they're in the middle. They promise economic incentive and legal protection subject to public purpose. But here, public purpose is qualified in a very pragmatic and definable way. Public purpose is defined as extreme security exceptions having to do with war or security. So that you know that regulatory issues such as licensing, guarantees, subsidies, trade policies, these issues are not, these indirect expropriation issues are not going to hurt you. But when you look at the bilateral investment treaties corresponding to these nations, you see another set of representations that do not really go together. So how do we tie all this up? We say, let's look at the foreign investment protection statutes with brand new eyes. That could be a mechanism for the global community to define public purpose, to qualify it in a meaningful way. Let's look at foreign investment protection statutes in a way that also tell us what the policies are for internally for states with respect to the protection of foreign investment as evidence of intent under Article 38 of the ICJ statute. It's the practice of nations. So there are ways, I think, where we can use these statutes institutionally as a global community, even though these are pieces of legislation, of course, that are national in character, that can be harmonized and can bring together a single voice in the field of public purpose and foreign investment. That can be very, very interesting. It also can be evidence of state practice and intent with respect to things such as policies having to do with foreign investment.
Other questions? Yes, right behind Professor Gibson.
Firstly, thank you for your comments, everyone. But does that not then pose the same potential issue if in foreign investment protection statutes, states adopt different perceptions as to what constitutes public purpose? It still has that whole elusive nature and that specificity that is currently there. Does that not mean then harmonization is only there to the extent that it's possible, and it might still present us with the same issue? And then with relating to the state practice element, is there not a suggestion then of possibly a customary international law standard then of public purpose? Or are we still going to apply rules such as regional custom, persistent objectors with regard to specific standards?
A lot depends on, first of all, thank you for the question. I think it's an excellent question. How it'll play out ultimately is less than clear. A lot of this depends on being able to create the same notion and purpose and objective at a transnational level. Otherwise, it just doesn't work. You keep having the same asymmetries. But what we're seeing, though, what I think is the more functional and theoretically attractive issue is that we see states that are developing states, and some are actually industrialized states, who are willing to say in the public records, in ways that are legitimate, at least ostensibly as to form, i.e. statutes, that safeguarding foreign investment is a priority with respect to all things except national security and war. And I'm not saying that that should be the qualifying element, but what I am saying is that this gives us a conceptual breach to work with in understanding the doctrine and how it can help us understand better both intent and the workings of what states really mean. You know, when you look at the arbitral awards, very few arbitral awards go deeply into the issue of public purpose. And in terms of, foreign investment protection statutes, they mention public purpose, but not in terms of foreign investment protection statutes. The FIPS are scarcely only have a perfunctory presence in arbitral awards, if any. We're told by the U.S. Department of State, for example, that they're not to be really relied upon because of corruption, and also a number of them do have, they're configured as having too many carve-out provisions that wrest the heart from the entire series of promises with respect to the protection of foreign investment. So there are a lot of problems with that rubric, and certainly your observations are keen and on point. But our contribution is limited to say, look, this is out there, this is what it says, and this is how we can do better with it.
So when you start, again with the Greeks, it's about what that polity wanted, what they thought was their public purpose. And you make this statement moving from independence to interdependence. So it reminds me of the language that in the New Haven School of inclusive interests, exclusive interests, and I didn't know if you thought of which public policies seem too centric to a particular state or somehow bridge states. Did you do that type of?
Well, perhaps in a limited sense, yes. I mean, in looking at, for example, does regime perpetuation constitute a legitimate public policy under any analysis? Well, for some states, they would say, yes, of course. We don't feel, for reasons that we articulate, that that's really what's intended to safeguard action. We did not so much look at public policy as a public purpose as a transnational idea in the sense that you're talking about. I think a purpose going beyond the polity, but an international purpose. But I think what we're really looking for is an international consensus as to the scope of regulatory sovereignty, which I would say is still sort of state-centric.
Mm-hmm. It's very state-centric, right? Mm. I'm sorry, more questions from the floor?
Can I ask a question?
Yes.
I was curious to see, in fact not to see, if I have missed it, but a reference to the annex on expropriation. And I wonder whether that so the emphasis on how NAFTA was framed and how it was interpreted and your dissatisfaction, and I wonder whether you find some positive possibilities in the way that the concept of interactive provision has been defined in that context. Now, this is a bit technical. It doesn't go into the question of who determines what, but maybe along the same lines that you try to find this commonality, whether from domestic investment legislation or from the new bits of individual states, particularly model bits. Maybe you get a sense of what may be the the values that should be and how those values interrelate to each other.
Let me add a twist on that, and that is, so you mentioned looking at these national statutes, which I would have said are not practiced for the purpose of custom, because a number of states would have said, well, now I'm doing better, I'm more developed, so I'm going to take that back. I didn't feel I was obliged to give that much protection, and now I'm going to make it a little less. But if you looked at, it would be hard, but if you looked at negotiations between investors and states, and would there be some consensus about how much regulatory space, when am I being extreme in demanding this much regulatory space? When does the investor think that's asking too much or I'm going to get a good deal, if you could somehow get their private view, if I get that out of the public space?
We see that. I mean, we see it. We don't see it clearly the way you're framing it as a question, but we see. Let's go adding together both observations. When you look at the NAFTA papers, as I know you have in considerable detail, you think about it first. First of all, what are the elements of NAFTA? Well, in NAFTA, you have 2 capital exporting countries and 1 capital importing country. That, I think, is a helpful hint to the demands and the dynamic that took place in those negotiations. For example, on the issue of compensation in the NAFTA, that's a fascinating issue where the capital importing state, Mexico, wanted to have compensation defined by its national laws. And the 2 capital exporting states, fought hard and won on that issue. Look, part of the dynamic part of the dynamic of the negotiation at the end of the day, you see it and I don't want to sound obvious, but you see it in the actual terms of the bid, and you see it in the actual terms of the multilateral investment treaty. You find areas where you have a formula for compensation that doesn't really comport all that well with other reservations that clearly have been negotiated and now constitute a limited public purpose category and not a more universal one, for purposes of trying to make up for the give and take and the concessions of the negotiating process. So obviously, I don't think you're going to find, and I don't want to say we ever will get to a point, but I don't think it's practical to anticipate or aspire to clauses that say the regulatory imperatives of the state will be limited to A, B, and C, or if they transcend A, B, and C, in no way are to cause a diminution in value to any foreign investment. I don't think we'll see that, but in that form. I think the way we can aspire to get that level of equity and transparency, which at the end of the day is what we're asking for, ultimately, when we want a global constitution or we want things to be done in a certain way that is rational, subject to discursive reasoning and transparent. I think we get there through the transparency of concepts and the development of concepts.
Yes, Chris?
Just one other quick comment. I suppose if you were going to try to approach it and have a consistent treatment, that goal somehow, you'd have to also cover doctrines like margin of appreciation and other things that are going to be part of the process of deciding particular cases and could open up sort of the Pandora's box of exceptions if you don't also try to come to commonality on what those kinds of terms mean in this context.
Yep.
I'm skeptical about the idea that there would be a creation of customary, international customary rules on the public purpose. I'm quite skeptical. And I'm not sure we would gather that we would comply with the uniform practice, state practice. I'm not sure we can really think, really collect, find, identify, and collect such a uniform, repeated state practice as the public purpose. I'm afraid we still fall into the unilateral approach, unilateral determination by each government, as always. First, at the unilateral level, by each state, and then in multilateral treaty making. I mean, NAFTA is just a multilateral treaty, only with 3 states parties. So I'm afraid there is little room to come to universal customary rules. There is very little room to get there. I think public purpose will remain a determination at the national level by a single state, both first of all in its definition and certainly in its content. Public purpose will remain a definition by each single state. Of course, again, in multilateral treaty, which is the NAFTA context, that's different, but otherwise states will continue defining the definition and above all content of public purpose on a unilateral basis. That's always been the case.
I'll ask you a question. What strikes me when Pedro says perhaps what's key is developing concepts. What strikes me as strange about custom is that we speak of customary rules, but we tend not to speak of customary principles. One would think, to me, you actually, in a historical development, you would have found customary principles before you found customary rules. However, the way international law developed, there was someone a little dominant who made it a rule kind of quickly, and then practice coalesced around the rule in most cases. Some cases it didn't work. But the problem I have with the customary principle, although there's some examples of it in some of the cases, is it's too vague, and it leaves, therefore filling out the principle is tough in any particular case. Either you're leaving the state range to say, well, I'm inside the principle, or you're leaving the particular tribunal range to decide, well, in this case, the principle is this. And so for counsel, it wouldn't be particularly satisfying.
Sure. No. One very interesting aspect that we have seen where states are reaching a consensus on public purpose, for example, we find in some ICJ cases, and there's a very interesting Ninth Circuit United States case, circuit court case, called Siderman de Blake versus the Republic of Argentina. It's one of the 1605A3 expropriation exception cases to the foreign immunity accorded to states under U.S. law. Under U.S. law, a country can be sued only if one of 8 exceptions apply, and this is one of those exceptions, a certain type of expropriation in violation of international law. And that's where the expropriating state expropriates the property and then gives the property to a private individual. There has been unanimity. Similarly, in cases of corruption, where the expropriating state expropriates the property and you know, the regime, in effect, the individuals keep it. There too, there has been unanimity. So if we look at historically what's happened, we do see a very significant movement towards consensus and transparency on this key issue. But the crisis with public purpose, and I want to just share it with you, you can see its lack of development in the restatement. And it's very interesting. Just listen to this. This is the restatement second, section 185. And this is what it has to say, the restatement of law of the American Law Institute that purports to restate, to state
Foreign relations law.
Foreign relations law. That's right. No, we of course, and it's not the one international arbitration either. It says as follows, quote, or the one on contracts, or the one on torts, or the one on labor. It says as follows, quote, although the requirements that the taking of an alien's property be for a public purpose is frequently mentioned in international adjudications and in the works of text writers, there is little authority in international law establishing any criteria by which a state's own determination of public purpose can be questioned. There appear to be few of any cases in which a taking has been held unlawful under international law on the sole and specific ground that it was not for public purpose. Now, 2 decades later, 20 years later, the same Foreign Relations Restatement of Law of the American Law Institute, the same section, 185, reads as follows. Quote, the requirement that a taking be for public purpose is reiterated in most formulations of the rules of international law on expropriation of foreign property. That limitation, however, has not figured prominently in international claims practice, perhaps because the concept of public purpose is broad and not subject to effective re-examination by other states. Close quote. So again, you know, what we do see is a type of crisis, and in fact there have been some voices out there that have said, well, let's just forget about public purpose altogether, which is, I guess, a legitimate position, and one that invites thought, and therefore, I think, a very genuine one. Hardly do I think that turning your back on a concept that is so embedded in our Western tradition in virtually every aspect. If you look at the 3 major human rights treaties, the Inter-American Convention on Human Rights, the European Convention on Human Rights, and the African Charter on Human and People's Rights, You'll also see how public purpose plays a pivotal part in creating a hierarchy of human rights. So that the right of free association, for example, is quite different from the right of being free from torture, or the right to have a name, or the rights of children.
Ryan, last comments? Or
Well, sure, happy to have them. I think picking up on Guido's point, this is not something that will happen tomorrow. We view it as, to the extent that this participation of the international community in refining and developing the doctrine can take place, it will of course take a lot of time, and it will be a feedback loop. You'll have progress on different fronts. You'll have FIPS being enacted that hopefully converge. You'll have arbitral decisions that hopefully further refine the doctrine. You'll have steps in the direction of state practice and custom, all hopefully reinforcing one another. We think that there's some hope for this result because, as Pedro said, we're now left with a doctrine that doesn't have an effective meaning, that no one really knows what to do with. And we're seeing that states' interests are becoming less polarized. And so we think while we've, in one sense, just said there's a problem and here are some steps that might go in the right direction, that there is hope. There's hope yet for arriving at a coherent and comprehensive doctrine.
good. Well, please join me in thanking our two authors and thanking Federico for his comments. Thank you very much. Please continue the discussion. Come on down if you'd like. Small enough, we can do that.
Absolutely.